Welcome to Navigating Complex Divorce and Parenting Issues with attorney Melanie Walls.
Welcome to Navigating Complex Divorce and Parenting Issues with attorney Melanie Walls. Melanie is an OSBA certified specialist in family relations law who helps individuals and families resolve complex financial and parenting matters with clarity and structure. I'm Leanne Lyon, and today we're talking about modifications to existing family court orders. What is needed to prove a modification is necessary, types of modifications that are possible, and how to start the process right away. Melanie, for people looking to change an existing family court order, what actually qualifies as a substantial change in circumstance in Ohio courts?
Leanne, in Ohio, when it comes to child support, there has to be a 10% deviation, either up or down, on the worksheet. There are misconceptions out there. Someone quits their job, for example, or gets fired, and they think that they can come in and change their child support obligation. It doesn't work that way. It has to be an involuntary change. For example, if you're laid off or your job is eliminated, you can't just decide you don't want to pay child support anymore and quit your job. It just doesn't work in Ohio. So when you come into court with a new income, whether it be up or down, it has to be involuntary. And then the court calculates the child support worksheet, and the end result has to be 10% up or down from your original child support order. When it comes to parenting issues, such as a change of custody or the parenting schedule or some change that you want to make to parenting, the Supreme Court decided a long time ago that they're going to set the bar very high. And they do that because they don't want a constant tug of war between parents. They want the children to have stability. So, for example, if mom or dad moves, 50 miles away, well, that may or may not impact the parenting schedule. Or can they still get the child to school in the morning? Can they get the child to extracurricular activities? How much of an impact does that really have on the parenting schedule if they only move 50 miles away? Now, if they move to another state, if they move somewhere that makes the current parenting schedule unworkable, then you're definitely going to see the courts change that parenting schedule.
That makes sense. But so how do you help clients differentiate between what they want for their child and what the court legally defines as the child's best interest?
A lot of times when they come into the office wanting a parenting change, it's a very emotional issue. So you have to try and separate emotion from evidence. A lot of times what works for me is I do a role reversal. Okay, mom or dad, you're the judge. I'm the parent. Here are the best interest factors. For example, the child's adjustment to school, home, community. How long has the child been in that school? How long has the child been in that neighborhood? And you let them sit in the driver's seat, so to speak, and have them see it from a different perspective, not just their emotional perspective as a parent, but as, okay, you're the judge and you're hearing this evidence. Do you really feel that this requested change is in the child's best interest? And I found that's a pretty effective way to handle this situation, and it really helps them see it through the court's eyes.
Well, given your business background, how do you handle child support modifications when a parent's income is complex, like with family-owned businesses or high net worth investments?
So with my financial background, it makes it easier to do a deep dive into the finances, especially the tax return. Taxable income doesn't necessarily mean what is the available income for child support or spousal support purposes. For example, on your tax return, when you itemize, you may use mileage as a deduction. Well, that is not an out-of-pocket cash expense, so that is going to be added back into your income. Depreciation. If you have a business, you're depreciating equipment. You might be depreciating vehicles. Well, guess what? That's not a cash transaction. That's going to be added back in to your income for support purposes. Personal expenses being run by the business, those get added back in. So all of that comes into play when you're looking at, high income individuals, or if you're looking at someone with a family owned business, those get added back in. People think, okay, this is what my, 2025 income tax return says that I earned, on the line item. But then you've got to go to the schedules and look at their schedules and add those items back in. So someone who may start out with 200,000 as their income may end up at 300,000 by the time you add back in mileage and depreciation and other things on the tax return that the IRS says is okay to reduce your income by, but domestic relations courts do not allow that.
Many parents just handshake on a new schedule. Why is it dangerous to modify custody or support without a formal court order?
Side agreements aren't enforceable. The court looks at what was the last order filed in the case, and that is what they are going to enforce. I mean, side agreements are dangerous. Mom and dad might be getting along this month, and then 6 months from now, they're not getting along. And guess what? Mom may have said to dad, hey, you don't have to pay me child support. Let's just, cover these expenses. But that's not an enforceable order. And dad is under that child support obligation. So guess what? He's got a bunch of arrearage that the court isn't going to change. Some things, though, develop a pattern. For example, let's say mom and dad agree we're not going to follow the schedule in our shared parenting plan. We had Monday, Tuesday, mom, Wednesday, Thursday, dad, alternate weekends. Let's just go to week on, week off. They do that for a year. Dad gets mad at mom and says, I'm not doing this anymore. We're going back to what it says in the shared parenting plan. Well, mom could then file a motion to modify the shared parenting plan and say, look, we've been doing this week on, week off for a year now, and it's really working for the children. So in that case, even though it's not enforceable, you may be able to get that adopted by the court as an order if the court finds that that's in the best interest of the children, and the fact that they've been doing it for a year is also going to help get that adopted by the court. But as far as the court enforcing that modification, they will not do it because it is not a court order.
Those are powerful distinctions. Thank you. At what age do Ohio courts start taking a child's preference seriously when it comes to modifying their living arrangements?
I love that question. We get it all the time from parents. Well, my child is 13, she gets to decide. Or my son is 16, he gets to decide. I'm not sure where that came from, but it's not the law in Ohio. It's still the best interest factors, which are adjustment to school, home, community, the health of all the parties, and many other factors. But you can do an in camera where the child or children get to go to court and they go into the chambers with the magistrate only, or if there's a guardian ad litem on the case, the guardian ad litem goes in. There are no attorneys, no parents, and the court gets to have a conversation with the child or children about different aspects of what is before the court. But a child never gets to decide. Teenagers are a perfect example. If you've got a teenager where mom is the disciplinarian and you have to do your homework and you have a curfew and you have, 1 hour of screen time a day, and then you have dad who, lets them stay up till midnight watching TV, or lets them go out after school, lets them stay on their iPads for hours at a time. Well, guess what? Who do you think they're going to tell the court that they want to live with if it's completely up to them? obviously a teenager is going to want to stay with the parent, whether it be mom or dad, who is the least restrictive.
Absolutely. Now, you are trained as a parenting coordinator. When should a family consider using a parenting coordinator instead of constantly going back and forth to court for modifications?
When you're filing motion after motion after motion on minor issues, what extracurricular activity is my child going to participate in? I want to change the holiday schedule this year from, Thanksgiving from 12 to 6 to Thanksgiving 12 to 8, when you're constantly having to go to court for every single minor modification of your parenting. That is when a parent coordinator can best help the family. They can help them solve the problems instead of constantly litigating over them, and provide solutions, and sometimes think outside the box and think about options the parents haven't thought of. And it's more problem solving oriented than litigation oriented. And I think that's beneficial to not only the parents, but to the children, because there's not this protracted litigation for 6 months over whether or not the child is going to get to play soccer. When you have a parenting coordinator, they get mom's position, dad's position, look at the schedule, maybe talk to the child, and then they issue a decision. So it's more cost effective, and it's a quicker resolution to the issue, which helps everyone involved.
For sure. Well, if a parent needs to move for work, what are the biggest legal hurdles they face when trying to modify a parenting schedule for a long distance arrangement?
That goes back to the best interest again, the child or children's adjustment to school, home, and community. If the children are little, two, 3, 4, 5, 6, they don't really have a lot of friends and school connections because they've just started, they're in kindergarten or first grade. It's a lot easier to try and get a relocation through the courts. But the other issue becomes the parenting schedule. If you have equal parenting and you have a parent that wants to move for work from Ohio to Texas, well, guess what? How are you going to get the other parent parenting time? It's extremely difficult. I mean, some relocation cases involve more time during the summer. So if they are too far away to make weekend visits feasible, a lot of times you'll do a long distance schedule, which is, 1 week after school ends to 1 week before school starts. They go to live with the other parent. All your 4-day holidays, Memorial Day, Labor Day, spring break, Christmas break, they would go with the other parent. And then the question becomes also, the school issue. What grade are they in? How long have they been at this school? One of the hardest things to get a court to do is to change a child's school. Courts are very resistant to changing a child's school. So that is also a big hurdle when it comes to a parent wanting to relocate.
For families in a high conflict situation, what specific measurable standards for parental fitness do Ohio courts now look for?
In high conflict cases, they look for several things. Is one parent trying to alienate the other parent? Is there consistency? Are they following the court orders? When the children are supposed to go to the other parent for the weekend, is the parent putting up a roadblock, or are they complying with the court orders? Is there a parent who's constantly moving? Is there a parent who's not able to maintain employment? Are the children tardy a lot? Are they missing school a lot? Do you see that with one parent, the children are turning in their homework and getting to school on time, and the other parent, they're late for school, they have unexcused absences, they're not turning in their homework? Those are all things the court would look at. They might look at all of the school records. They might look at medical records. Are they not getting their well checkups? Have they not had their vaccinations? You could look at dental records. Are the children getting, the cleaning every 6 months? Or have they not been to the dentist in 2 years? Those are all things the court can look at when they look at stability for the parents and the children.
As we wrap up here today, when is a modification not worth the legal fees? And how do you advise clients on the financial reality of litigation versus the change that they're seeking?
On the child support side of that question, a lot of times people think that when someone gets a raise that it's going to make a significant change in the worksheet. So typically in those cases you would run a worksheet and show them, hey, this only made a $25 or a $50 or a $100 change in the child support amount. Do you really want to litigate this? You're going to spend X amount on attorney fees and only end up with an extra $100 a month. So that's more of a cost benefit analysis. On the parenting side of things, for example, a teenager who's 17 and a parent comes in and says, you know what, this parenting schedule isn't working. I want to file a motion to modify the parenting schedule. Well, by the time we file the motion, we do discovery, we get in court, you're going to have 6 months left and your child is 18 anyway. Does it really make sense to litigate something when you're almost at the end of the road and the child is going to be 18? So you have to look at, how much is going to cost, how long is it going to take in court, and will you meet your goals? What are your goals? Here's what it's going to cost. This is how long it's going to take. And does this make sense?
Well, that wraps up today's episode of Navigating Complex Divorce and Parenting Issues with attorney Melanie Walls. If you'd like to learn more about Melanie's work or schedule a consultation, visit melaniewallslaw.com. Thanks for listening, and remember to like, subscribe, and share the show so others can benefit from these conversations. Thank you, Melanie.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.